I call the Honourable David Parker.
Thank you, Mr Chairman. Can I thank the members of this House for their contributions today, and I do accept that everyone's trying to do the right thing here. I have two areas that I would like to traverse, Mr Speaker, and if the Minister would be so good as to reply to them. The first is, aren't we at risk here of creating a defence for the intermediaries who currently face legal risk if they publish defamatory content in respect of someone online? Do they currently face legal risk, which this safe harbour provision removes? Because if there are, let's say some of the people that make money out of activities that are allied to their online forums that they are publishing. And an example, I'm told by Claire Curran, is TradeMe. So TradeMe has an online forum, and the reason they do that is it attracts people to their trading site, and it's one of the services they give through their TradeMe site, and they make many millions of dollars every year through TradeMe. Now, at the moment, if they publish or allow to be published on their site things that are horribly insulting of people and maybe untrue, I think they're concerned that they face legal risk. Well, actually, that's not a bad incentive for them to keep their site clean and to keep it free of this sort of bullying. Are we at danger in terms of this safe harbour that we're creating, actually removing the legal risk that encourages them to be responsible at the moment? So that's my first question. Because if that is the case, then I think we should send this one back to the drawing board, because I'm not sure that we should be letting off all of the people who are making money out of this, the people who sell advertising services or services through these websites. They're the people who actually have the most ability to control what is on their site. I can't control it. Other members of this House can't control it. So I wonder whether we're actually making an in-principle mistake in respect of that. It's the first issue I'd like the Minister to address, because if that is the case, then the safe harbour provision could be making things worse rather than better, because it's avoiding legal risk that currently exists. And I'm not yet convinced that in the Western world we've actually got this quite right. We're moving into a new system in the world where the publishers of most content were reputable media who had editorial oversight and some standards from within. If we're moving away from that because of the changed revenue model for the media, why should we be enabling people in this new environment to have less risk than the old publishers of content through newspapers did? Those old publishers of content, they've lost their revenue to these new intermediaries like Facebook and Google and TradeMe. Why is it that the new people that pick up the revenue from these new sources of advertising and new commercial models don't face some of the old legal risks that used to control content in the way in which these things were previously published through the media? Second point, Mr Chairman, relates to the criminal provisions in Clause 19 of the bill. Mr Chairman, Clause 19 of the bill is a lot wider than the instance that the Minister gave in respect of the United Kingdom, where she said that revenge porn has been criminalised in the United Kingdom. And I can understand why that would be the case. But this goes a lot further than this, and this applies to any digital communication that causes serious emotional harm. It doesn't just apply to video clips. It could be an insult which someone finds offensive and to them causes them harm. Now, that seems to me to be a very broad criminal provision, and I'm again not convinced that we should be so quick to criminalise what could infringe free speech. Now, you'll have heard from my earlier contribution that I think there should be responsibility on the part of people that publish comments, and if they say defamatory things, and the sort of insulting things that we've heard of are generally defamatory, or if they publish things that are too personal, like videos and things that were taken in a personal, private space, then those things ought not to be allowed, and we need to have both. We need to have certainly civil remedies in respect of that, and in some instances at the most serious end of the spectrum, as they are doing in the United Kingdom, Mr. Chairman,
Honourable David Parker.
in respect of revenge porn, I can understand why you might want to criminalise in respect of that narrow subset in respect of insulting communications. But this goes a lot further. In Clause 19, the drafting of it says that a person commits an offence if they post a digital communication, which can include an email. So it could just be an email post on a website with the intention that it cause harm to the victim. Well, most insulting things, I think they generally are intended to cause harm. Harm is defined as being serious emotional harm. But, you know, that's pretty subjective. I would have thought that at the moment some of the things that are said in respect of politicians would be seen by politicians as causing them serious emotional harm if there are being allegations made of corruption or inappropriate dealings or, you know, conflicts of interest as ministers have, putting their personal interests in conflict with their ministerial duties. Posting that communication that would cause harm to an ordinary person in the position of the victim, and the posting does cause harm. So you could have something that is well-intentioned on the part of someone who thought that they've uncovered something that is terribly corrupt practice on the part of a politician, for example, and you could post that and you would think that you would, in that situation, have protections set out in the law that would apply to fair comment in respect of existing forms of communication. Now, this highlights one of the concerns that was raised in the minority report by the Labor Party, that why is it that we're having a special form of legislation only for digital forms of communication rather than more general? This highlights the point that we may not be protecting through this criminalisation provision rights of freedom of expression. Now, again, I make the point that given that we can have decreasing reliance on the traditional forms of media because their revenue model has collapsed, and we've got these new forms of media, this is the flip side of what I said in respect of my earlier comments in respect of some of the ISP liability. We actually might be going here and creating offences on the part of people who think that they are making fair comments in respect of things that are issues of proper public concern. My concern about that is highlighted by subsection 2, which says in determining whether a post would cause harm, the court may take into account the following circumstances. It doesn't have to, it's just may. And then one of the things that they may take into account, but don't have to, is whether the digital communication is true or false. So what we're saying there is that actually a digital communication might be true, and the court could still find, if it causes serious emotional harm, that it is something that is in breach of this law. And I think that looks like that's bad law. And so the Labor Party will be supporting the ACT member David Seymour's amendment here to delete clause 19, because I think that needs to be looked at properly. And we shouldn't be passing, there's no reference to the Bill of Rights Act. We don't know whether this overrides the Bill of Rights. It probably does. It's more specific legislation. It's later in time. So it may well be that this overrides the provisions in the Bill of Rights Act, and I don't like that. So, Mr. Speaker, I would appreciate the Minister's comments in respect of the first issue, and also to explain why we can't actually take a leaf out of the UK book and be very careful to limit the criminal penalties to specifics rather than generalities, perhaps in private or indecent videos. You know, I would have no problem with that being criminalised. I do accept that there are problems with cyberbullying. I suspect this isn't going to fix it because, of course, by the time you've gone through this safe harbour provision, this will be the offending thing, if it's gossip around a school, will have been on 100 different Facebook pages and it'll be out there. And so it'll be an ineffective piece of legislation, but nonetheless we're inappropriately, I suspect, constraining rights of free speech in a way that we haven't thought through properly. It's interesting that the Select Committee report doesn't actually deal with any of these issues properly. None of them. None of the two that I've raised. I don't think it just touches upon them very lightly, and I don't think it has it shows an in-depth consideration of what I think are difficult and important issues. Thank you, Mr. Chairman.